Good afternoon, everybody. Keith here. Haven't been on for a while. Been dealing with issues and trying to take care of them. But I wanted to get on real quick and do a short video today about a simple notice and how I manage them to keep things out of the courts. Okay? Because it's already been in the courts. It's already been established. There are things that have already been established. And when we're dealing with situations in apartments, living units, various things that are under the housing and urban development, and we know they're all under the housing and urban development because it's in the urban area. Okay? And so when we're dealing with these housing and urban developments, in the original construction contracts, they provide for insurance through conservation easements, and this is in regards to the safety of lives, regardless of what kind of life it is. And so when we're dealing with the housing and urban development, it's obviously not the lives of dogs and cats, though it may include them, just like it may include the fish in the fish aquarium or other kind of different pets, as we know them, generally part of the family. But the life and safety that they're really talking about is the people. Okay? So when we call up a landlord and tell them that there's an issue with the furnace, let me turn my camera around. There's an issue with the furnace, and we notice it because though it's reading 65, we actually had to set it to 74 to get it to reach 65 degrees. Okay? This, first and foremost, is a sign of inefficiency. And when we realize that it's inefficiency in regards to the costs, it's not just a cost to us, as if though we're the ones paying it. It's already set out. This is a cost through the utility companies. So and they're in agreement with the state, and it's funded by the state. So it's actually a matter of sustaining the state's budget by showing that the equipment they're using for safety reasons is faulty. Okay? And in that fault, we notice the landlord. He sends out a worker, and they do something. Say, okay, there you go, you're all taken care of. And then they take off, and it seems to work for a short time. And then you have to call them up again, because it does it again. Okay? And if you know anything about furnaces, they've got little panels on there. The one down here at the bottom, now this, it just kicked on. Okay? I hope everybody heard it just kicked on. And this door here, it's got a handle in it, and you lift up, and it'll pop out at the bottom, and then you can drop it. And once you do, that furnace should shut off. Okay? But as you can see, it's still going. There should be a kickoff switch when you remove this panel. Or maybe it's the bottom one. I don't know if I can get the bottom one off. Should be able to kick it up too. But there should be a switch on here somewhere where you can shut that off. But the issue is that even as a general education in electronics, you know that all the wires should be nice and clean and have good clean connections and no corrosion, and they certainly shouldn't be burned up and spliced together, disconnected from the sensor that helps enforce the safety of this piece of equipment. See, this piece of safety equipment in regards to the general welfare and domestic tranquility of the beings living within this housing unit, whether it be me and my companion or somebody else, it doesn't matter. That part doesn't matter. The part that matters is that the equipment being provided is operating functionally correct. And as we can see, that is not correct, and therefore it can't possibly be functioning correct. So when we establish this information and we make record of it like I'm doing in this video, so I can send this to the landlord in support of the notice that we already sent. The notice that we already sent showing a picture of those wires and a simple statement about HUD would never allow that, and that I would prefer to notice the landlord to take care of it appropriately by getting the proper furnace technician out here to take care of the problem, rather than a maintenance tech that's just going to do a cut and avoid bypass that doesn't allow the system to actually operate correctly, so that when we turn around and we're expecting that furnace to read 65, by setting it at 65, then it should be so. But again, we're found to have to set it at 74 just to reach the temperature 65. So now we see it's a matter of cost efficiency in regards to the debts previously contracted with the state and the utility company, as well as their requirement as public trust servants to provide the best interest of the trust. So now we have the efficiency, we have the safety, and now we have the interest of the trust. And these are all three valid points that every court would agree with you on. And it's basic and simple. So that's all we do in noticing anybody in our lives anymore. And I've showed examples of this many times. The clerk of court that wants to accost my companion through the mail, I don't write them a letter. I don't even open their mailing. I abate it right on the envelope and send it back to them. Okay? If you notice here recently, I've got an issue with the Postal Service. I haven't called them back yet to speak to the Office of Inspector General or whatever, I guess, about the Postal Service sending mail back to me that I abated right on the front of the envelope, showing that it was in fraud. You can't take a proper notice given and just rebuke it as if though it doesn't count. It does count. That's notice. And for you to refute the notice, that's a violation of trust law, particularly as the judicial officer who is supposed to be part of the judicial officer department, a neutral and independent forum within the United States Postal Service and the Postal Regulatory or Postal Service, consisting of or comprising of the Administrative Law Judge and the Postal Board of Contract Appeals. So here you are, you're taking mail that is under the pretense of fraud in contract venues, under a trust formation, and you're denying it. Well, I take that as evidence to the International Forum to show that they're violating their code. It's their employee, and their employee is the one that's violating their code that I pointed out to them. I'm not employed. However, now that you've drugged my ass into this and made me communicate, and let me tell you, I charge $1,000 for pen pal services. Okay? What do you think I charge for legal services? That legal service, each one is a small claims. $5,000 for legal services as a small claim. You want my pen pal service, it's only $1,000. Okay? So right now, as it is, private communications, it's not pen pal services, it's a notice. But if you want to sit there and bicker back and forth through pen pal services, it's going to be $1,000. But if you want to start making accusations and charges and try to threaten to remove myself and my companion because we make your job harder, because you have to actually do your job, then that's on you. You know, I don't play games with anybody, including the post office. They already know this. And why they're not paying attention here locally, I don't know, but they better. Because now, like I said, I'm going to the post office inspector general. I'm not going to play this little monkey game down here at the local level. You already lost your ability to say that you're competent of being a postmaster by sending it back to me. And now I've got evidence that you gave me proving you can't possibly be a postmaster, because the simple basic of your job is knowing that if there's something in fraud, you can't let that go. You have to correct that with the general ledger within 3 days. Now, I gave you notice that was out of balance of the federal ledger, and now you're sending it back down my throat as if though your job doesn't count, as if though you don't have to do your job. Yeah, you do. That's the basic foundation of the trust. Postal Service, the Global Postal Service Trust. That's the trust that everybody's dealing with in all these communications, whether it be definitive paper form or on the internet through electronic communications. It's all protected as literary artistic works. If the work is protected, then it better be true, because if it's not true, then I have the option to rebut it. And when I rebut it, you try to shove it down my throat. Now you're taking over the inherent protection that I have of protection of literary and artistic works to express the trust. Therefore, you're denying the trust. You're not just denying a contract. Now you're denying the trust. So a simple communication is all it takes. But you got to have all the knowledge to back it up so you can follow it through. This is why I do this stuff. There is no other proof other than what I've put out. You're not going to find my proof in their public record or their public register. It's not there. What you're going to find proof of in their public records is that they've used that name and number, which identifies the record, against the living beneficiary heir. That's the evidence on that record. And I can prove that. Whether you can prove that or not is different. But once you get that knowledge and you start proving this stuff, all you do is shove it right back at them. That's not so. That's not so. That's not so. That's not so. What are they going to do? Disagree? Are they going to disagree with the fact that they're trying to say that, well, you signed it, so you got to be liable. We got to hold you liable because you signed it. What about UCC 3-402 that specifically says that the authorized representative giving an unambiguous authorized signature on the instrument is therefore not liable for the person named in the instrument? Well, no, that's how do you? That's plain writing. You can't just excuse it away. You can't cop-splain it. It's plain writing. And everybody can comprehend that. It says, I'm not liable as the signer on the instrument for the person named in the instrument. So again, we go right back to what I just said a minute ago. The name and number identify the record, not the living beneficiary heir. And as a living beneficiary heir, in order to take benefit, I'm qualified and authorized to sign this document. Whereas you converted it as a public liability. How can that be? I was never assigned the proper capacity under taking an oath to be able to place a liability on the public record. So again, that public record is known as a liability, and that's not me. I'm the asset side, not the liability side. Without me, you wouldn't be able to create a liability side and put it in a public venue for a Keith Orland Little. That wouldn't have been possible. You have to have the name before you can enumerate it. So, again, think about this stuff. It's simple notice by noticing simple things and giving them a knowledge of it. And like I said, I'm not a furnace technician. I'm not an electrician. But I do know general concepts of how things are supposed to work. And if they're not done appropriately, then there might be something wrong, and we need to pay attention to that. Well, I'll be damned if nobody wants to pay attention to everything that's wrong in their life. They want to put it on somebody else. They want to call up the landlord and say, hey, the furnace isn't working. So I have my part in taking responsibility of laying that responsibility on the landlord's tech worker by letting the tech worker do his job. And if I feel he doesn't do it right, I've got to make a record of it. Observe, record, report, as my brother Derek says. I've got to play that responsible part in there. But it's only because I take part in that responsibility that I'm going to be able to benefit from it. Otherwise, if I don't take part and place myself in the proper position of that liability and responsibility, then everybody else is just as confused as I am and nobody knows what they're doing. This is the thing that changed everything in my life. I changed what I was doing because I recognized what I was doing was the problem with everything. As long as I quit doing the things I'm doing, I can't force other people as public service to put a liability on a record. So when I have to deal with these people in the public like this as public servants, I have to know that when they do something wrong, I've got to do my diligent part to create a record to show them how they've done something wrong before we try to create a record in a court. See, now the record's already established and they already know what I'm going to bring to court if that's where they want to go. But again, I assure you, they don't want to go there because, like I said, it is a simple notice. I'm sure HUD would find this as an egregious violation of the safety of their conservation rights or easement rights rights of way in the conservation easement to come in and inspect these. So since they can't come in and inspect them, I've got an inspection that I've done myself. And I'll give them notice of it if you don't take care of it appropriately. And that means make it right, not half-ass cobbled. I don't deserve half-ass cobbled, just like the guy that's paying monthly payments, housing payments for a $5 million mansion. Just because I'm living in a $650, $700 fucking month rent apartment doesn't mean I deserve less. Because again, it's already there. It's already preset. We're all set in the same standard of safety requirements, and that must be upheld above all else. First and foremost. Then we can get to the efficiency and the accuracy of the equipment and the record. But first and foremost, it comes to the safety. And again, I'm the only one I've ever found to be actually looking out for my own safety. That maintenance guy, he wasn't looking out for my safety. He was looking out for Caliber Group's cheapness to sustain their budget, which actually creates a detriment and a greater liability on the state's budget because they're the ultimate public trustee when it comes to everything interstate commerce. So we really have to think about this stuff and learn how to put these people in their place right at the place they're at. Don't let them take you to court. It's not where you belong. They can never pull me into court. I can prove that I don't belong in those courts. I also have agreement from not just the courts, but all kinds of associates along the line saying he's not going to sign that document. While they stress that they need that signature. While at the same time, the law says, well, he's not liable for his signature. Why do you need the signature then? So think about this stuff, people, and remember, if it wasn't for you, I wouldn't be doing this. God bless you. Love you. Have a great day.